I'm really excited to have Mike Hunter and Ben Karb with us today. So this is celebrating our 30th anniversary for CAMS, and so we really do appreciate you joining. Part of our 30th year anniversary, we're doing a monthly giveaway with these sessions. So I do want to congratulate Donald Heath with Windgrove Park out of Wilmington. He was our lucky winner from last month's session. He did win a $100 Amex gift card. So we will be doing a drawing at the end of this session. So please stick around, and for those that are attending will be entered into the drawing. So again, we do thank you. As a reminder, we will be using the Q&A option or the Q&A feature through Zoom. So if you do have questions throughout the webinar, please enter those questions in the Q&A located at the bottom of the screen, and we will help facilitate those questions throughout the session. So we do also post these webinars to our website. So if you do have any board members that you'd like to share this content with, you can send them to the board member section of camsmgt.com. So all the webinars that we've hosted are located on that website. So Mike, Ben, I will turn it over to you, and then I will turn my video off and jump back on when questions do come in. So thank you.
Thank you. I'm Mike Hunter. I'm an attorney with Offit Kurman in Charlotte. We were formerly known as Horak Tally. Some of you may recognize that name. We merged with Offit Kurman about a year and a half ago. I've been doing condominium and community association law for close to 30 years now. And today's topic is something that Ben Karb and I deal with probably 3 or 4 times a month. We get inquiries from clients related to what the substance of this presentation is, namely document requests. And then also there's, I'm going to take the first half of this. Ben Karb is going to take the second half, and he's also going to include some pointers on meeting minutes, communications, confidentiality, ARC applications. And then he'll speak a little bit about topics that are peculiar to South Carolina. What I'm going to be covering is relates to North Carolina. My understanding is South Carolina law is very similar to this. So the statutes I'm citing are North Carolina statutes, but the principles will probably still apply to South Carolina as well. The first topic is just to talk about what records owners are entitled to see. And that's governed, every HOA, almost every HOA in North Carolina is set up as a nonprofit corporation. And as such, nonprofit corporations are governed by Chapter 55A of the North Carolina General Statutes. And if you go all the way to the bottom of that chapter in Part 16, it has a whole section on corporation records. And the first part of it is a list of records that members are always entitled to inspect, period. They don't have to state a reason. They don't have to state a good faith reason or what their purpose is. These are records that they're always entitled to inspect when asked. The first is your articles of incorporation and any amendments to those. Second is your bylaws and any amendments to those bylaws. The third is resolutions by the board relating to the number of classification of directors, et cetera. Now, frankly, I've never seen that arise in the context of an HOA, so that probably doesn't apply to most of you. Next is the minutes of all membership meetings and records of all actions taken by the members without a meeting, such as for the past year, we were conducting HOA meetings virtually, then having members vote by sending in mail-in ballots. So those ballots would be technically records taken pursuant to one of the statutes for the past 3 years. The next one is all, and this is important, this says all written communications to members generally within the past 3 years and financial statements have been furnished to members. Now, that does not mean a member is entitled to copies of every letter that's ever gone out to a particular homeowner. What that means is they're entitled to copies of written communications that were sent to all members, period. They're not entitled to see all correspondence that was sent just to one particular member or a subset of all the members. And included in that is the financial statements that have been provided at the end of the year. That's also covered in the North Carolina Condominium Act and the North Carolina Planned Community Act. So no doubt some of you have received records requests from members of your association. If what they're asking for falls into the categories of those 6 things, I'm sorry, the last thing is a list of the names and business or home addresses of current directors and officers. That's also required by the Condominium Act and the Planned Community Act, which says, and a lot of associations don't know this, those laws require that associations publish the names and addresses of all directors and officers within 30 days of their election or their appointment to the board. So those first 6 items members are always entitled to. The next section talks about other types of records that members may be entitled to. And the first list is they are entitled to copy at any time any of the records that I just described. Those first 6 at any time. Notice there's no qualifications to that other than that they have to give the corporation at least 5 days written notice, 5 business days before they expect the records to be tendered to them. The next section is talking about records that owners may be entitled to, but it depends. And what this says, and this is very important, they're entitled to see the records that are listed below if they meet the following requirements. And this is at the top of the 3rd page. They have to make their demand in good faith and for a proper purpose. And when they make that request, they have to identify with reasonable particularity what their purpose is and how the records relate to that purpose. And the records have to, in fact, be related to that purpose. Now, if they jump through all those hoops, the association is required to provide them with certain records. And those records are meeting minutes and board resolutions from meetings of the board of directors, accounting records of the corporation, and that's a fairly broad term. That doesn't mean necessarily just financial statements, income statement, a balance sheet. Accounting records can include general ledgers, technically bank statements, cancel checks, etc. And in certain cases, they are entitled to the membership list. But what's important here is that they have to, these records, they have to identify a specific purpose, a good faith purpose, and identify how these records are related to that purpose. And I'm going to talk in a few minutes about the kitchen sink request, where the member requests a lot of records, but he's not specific about exactly what he wants to see or why he wants to see them. Let's talk for a minute about the membership list. The Nonprofit Act does give members the authority to see the membership list, but only in certain circumstances. Their request has to be made in connection with their interest as a member of the corporation. In other words, they can't just say, I want to see the membership list, period. Well, no, you have to identify a purpose, and that purpose has to be related to your interest as a member of the corporation. You cannot provide the membership list to an owner who plans to use it to solicit money or property, or to use it for any commercial purpose, such as just send out e-blasts advertising their business or their services. And you can't, the membership list can't be sold to or purchased by any person either. So here again, if someone's asking for the membership list, they're going to have to be specific about why they need it, what their purpose is, and how the records are related to that purpose. The statutes also give the association the authority to charge a reasonable fee to the homeowner who's requesting the records, as long as it's reasonable and it accurately captures the actual cost of what the management company is going to charge for researching and producing, copying or burning them onto a disk or put them into a zip drive or whatever. Most management companies don't include records research as part of their base services, and that's generally an a la carte service where the management companies charge an extra hourly fee. And the homeowner who's requesting the records is going to have to pay that fee. And one thing I often tell my clients is, if somebody's requesting a lot of records, I generally would ask the management company to estimate how much time it's going to take them, what their charge will be, and make the homeowner pay for it up front. And if it ends up not costing that much, of course, you can refund the difference to them.
Hey, Mike.
Yes.
Before jumping on to financial records, could you talk a little bit about how South Carolina, or maybe Ben, could you talk a little bit about how South Carolina ties into a few of these sections?
Sure. Yeah. So South Carolina, we sometimes refer to South Carolina as the Wild West, but that's not exactly the case for some of these records. The South Carolina Code of Laws has, very similar to North Carolina, a Nonprofit Corporation Act. And almost every single statute that Mike just ran through is copied verbatim in the South Carolina Code of Laws. There's literally no difference between most of them. I'm not sure where, I guess there were, back in probably the 50s when all these laws were adopted, they just basically cut and pasted it from one state to the other. So really, other than the statute numbers, and in South Carolina, it's instead of 55A, it's actually chapter 33-31 in South Carolina, but it is virtually identical. The other difference in South Carolina is that there is not a comprehensive Planned Community Act, which really doesn't have a ton of stuff about records in it, but there's really not a Planned Community Act in South Carolina. There is a Homeowners Association Act that was adopted, I believe, January 10th of 2019. So it's a very, very recent law. And it says some of these documents have to be recorded with the county register of deeds or the clerk of court in a particular county. Whereas in North Carolina, some of these documents don't need to be recorded, like your bylaws are typically not recorded. In South Carolina, you do have to record those. But that's really the only distinction. So the laws that Mike just ran through are almost identical in South Carolina.
A couple of questions that are relevant to the first section, if you don't mind asking, or I can ask them.
Sure.
When you say minutes for all meetings, does that include those meetings outside of the quarterly and or annual meetings?
Yes. The homeowner is entitled to, without conditions, homeowners always entitled to minutes of membership meetings. For minutes of board meetings, they have to jump through those hoops that we talked about identifying a good faith purpose and how the records are related to that purpose. So yes, once they jump through those hoops, they are entitled to copies of all board resolutions and minutes of all board meetings. One thing they are not entitled to, and I'm getting ahead of myself here, is when the board goes into executive session or closed session to discuss sensitive or confidential matters. Typically, there is a separate set of minutes kept for when the board is in executive session. Those separate minutes are generally not disclosed to the members, and my instruction to my clients: don't give those out unless the owner can produce a subpoena or a court order or a proper discovery request that's been served in connection with the lawsuit. Now, the North Carolina Nonprofit Act actually doesn't make any mention of executive session or closed session meetings or minutes, but there's some mention of it in Robert's rules. And in North Carolina, condo and planned community associations are supposed to run their meetings by Robert's rules. So just keep that in mind when you do go into executive session to discuss violations, maybe vendor contracts, collections, delinquencies, et cetera, any pending lawsuits or threatened lawsuits. Keep those minutes in a separate set of executive session meeting minutes, and don't put those on your website. Don't make them available to owners unless they can produce a court order or subpoena.
Okay, I have two membership list questions, and then we'll turn it back over to you. But so do those restrictions on the membership list also apply to lists that are already generally available to the community?
No, what this is referring to is a membership list that the corporation maintains of its members. Now, obviously, anyone can go out to the county tax office website and get the names of all the property owners in the community. It will take some time. So yes, that information is available elsewhere. What this is referring to is the membership list that the HOA maintains for its own internal purposes. Does that answer the question?
I think so. And then can a member request a membership list for campaigning for a board position?
Yes. Remember, I said that the members are entitled to the membership list if their purpose is directly related to their interest as a member. And if they're campaigning for a board seat, absolutely, that request is directly related to their interest as a member. If they were requesting the list because they want to send out emails advertising their insurance brokerage services or their real estate agency or things like that, obviously that has no connection whatsoever to their interest as a member of the HOA. So that's the key point, is that nexus between their purpose and the need for the records has to be related to their interest as a member.
Okay, well, I'll get back to questions in a little. So financial records.
Okay. Actually, on that point, I was reading today a summary of an appellate case that came down a few years ago that was talking about this relates to ballots and proxies mostly, and this is a good example of what's a proper purpose. A homeowner requested copies of all the ballots at the recent annual election. The HOA objected because ballots are generally confidential, because homeowners don't want other people seeing how they voted, just like any other election. The association said, we're not going to give you the ballots, but what we will do is allow your attorney to come look at the ballots and count the votes and report back to you the tally of the votes to confirm that the results reported by the association were valid. The homeowner said, no, that's not good enough. I want the ballots themselves. Well, it went up to the Court of Appeals. The court said, I'm sorry, homeowner, you haven't stated a proper purpose. If your only concern is determining that the election was properly decided based on the ballot counts, you don't need the actual ballots. You just need to know the count. So therefore, your request is denied. So that's a good example. That's a real world example. Let's talk about financial records for a minute. Both the Condo Act and the Planned Community Act require the association to make an income statement and balance sheet available to the members within 75 days of the close of the fiscal year. Now, note it says made available. That doesn't mean those financial statements have to be mailed out to the owners or emailed to them. It says it has to be made available, which means if they want a copy, they should be able to get a copy at no charge. A lot of HOAs will post their financials on the password protected website. If somebody wants a copy, the management company can certainly send a copy of it to them. And one other thing, and this is actually all the years I've been practicing, this has never come up, but if a claim is made against a member of the board of directors and the corporation is going to have to indemnify that director for any claims against him, notice of that has to go out to all the members. Okay, let's talk about the what I call the kitchen sink requests. No doubt most of you have encountered the disgruntled homeowner who's mad at the world, mad at the board, whose life's mission it is to make the board miserable, sends in all these document requests, just requesting dozens and dozens of documents going back years and years. They come up with some cockamamie reason on why they need them, don't really articulate what their purpose is, and don't specify how these records are related to that purpose. That's where you can use those provisions I talked about earlier to deny those types of requests. If they can't prove a good faith purpose and how the records are related to that purpose, you don't have to provide them with those records. And also, if they're requesting a whole lot of records even if they are entitled to them, once the management company says, well, we can do that, but it's going to take us 3 hours to come through the records and make copies of all these and get them to you. And our rate's $75 an hour. So you're going to need to pay us $225 in advance. A lot of times they'll go away once they hear that. Because a lot of times their purpose is just to harass the board. And they think by making a large document request, that's what they're doing, but they don't realize it doesn't really affect the board. All right, let's talk for a minute about what records the members are not entitled to inspect. This includes vendor contracts and vendor invoices. And the reason for that is a lot of your vendors may have proprietary or confidential information in their pricing or their methods of pricing or delivering services that they wouldn't want to get in the hands of their competition. They are not entitled to any information relating to violations or enforcement actions taken against other members. Remember, we talked earlier about how members are entitled to all written communications sent to all members. They are not entitled to written communications sent to individual members. And those are considered sensitive and confidential documents, and owners are not entitled to see copies of correspondence sent to their neighbors. They are not entitled to see account statements for other members. For example, someone wants to know who's behind in their dues and they request a copy of the account statement for all members. No, they're not entitled to those. And if the association did provide those, they would be violating both federal and state laws that govern debt collectors. They are not entitled to ballots or proxies from annual meetings or from any meeting for that matter, for the reasons I discussed earlier, which is most people don't want others to see how they vote. Voting typically is done by secret ballot, and owners don't necessarily want others to see how they voted. Just as the appellate course I just described a few minutes ago, you can certainly give them a tally of the votes, and if they want to have their lawyer or someone else come and review the ballots, don't give them copies, sit down at a table and go through them and count the votes up themselves. That's fine, as long as the attorney does not share with his client the names of anybody or how they voted. Owners are not entitled to copies of any correspondence between the board and their attorney, provided that the communication is a privileged communication. Now, not all communications between myself and your board of directors are necessarily confidential and privileged, but depending on the topic being discussed, it may be privileged. A lot of times I'm asked to write opinion letters on various topics or HOAs and addressing a dispute over maintenance or insurance coverage or something like that, or some other violation. And I write that opinion letter. It's addressed to the board of directors. I am discussing legal concepts and legal issues. However, a lot of times after discussion with the board, I'm writing that letter with the full knowledge that it's going to be shared with one or more homeowners. And I keep that in mind as I'm drafting the letter, and I don't put any confidential information in those letters. I've had on numerous occasions over the years, boards come to me and want to know if they can publish a deadbeats list with a list of all the names of owners who are behind in their assessments and how much they owe. Absolutely not. That's going to get you sued. Here again, that's a violation of both state and federal laws that govern consumer debts and debt collectors. That'll get you sued. It's okay to publish information on total delinquencies, but you can't put any information there that would identify a particular owner or even their unit number or their address. You can just summarize all of the accounts receivable. For example, we've got this much that's 30 days past due, this much that's 60 days, this much that's 90 days, and here's the total, but that's the extent of what you can disclose. One of the most frequent complaints we hear from homeowners is that my board operates in secret. They never hold meetings, they never send out emails, they don't publish newsletters. We have no idea what they're doing. They don't hold meetings, they don't communicate with us at all. We don't know where our money is going. They don't provide us with financial statements. Transparency is a very good thing in an HOA. And a lack of transparency is, as I said, one of the biggest sources of complaints we hear from homeowners. And a lack of transparency leads to nothing but suspicious and contempt on the part of the homeowners. Ben and I are big proponents of transparency. There are a lot of HOAs that make all of their board meetings open unless they're going into executive session. You don't have to make all your board meetings open, but some of them elect to do so. Ben, do you want to talk for just a second about this Almason versus Southgate on Fairview Condo Association appellate case? I think you knew something about that.
Are you asking me or Ben Rhodes?
Yeah, Ben Karb. Mm-hmm. And Ben Rhodes, were you involved in that too? I noticed you said you were familiar with an appellate case. Is that it?
I was very involved with this one, so.
Okay. All right, well, y'all can share some experience on that. And then from that point, Ben Karb is going to take over and carry the rest of the presentation.
Yeah, so I'll talk about that case briefly. I don't know the parties. We were not involved. Ben Rhodes may be at liberty to speak more about it after I finish, but I'll let him make that call. So there's a condo in Charlotte called Southgate on Fairview. And I guess there's an owner there that was pretty unhappy with the board. From what I could gather, he was basically just very suspicious. He kind of thought that the board was basically doing underhanded things. So they had approved the budget without a proper vote and things like that. So he hired an attorney that we are all very familiar with, and they sued. Basically, they did a kitchen sink document request. They requested, I don't even know how many categories, 30 different categories of documents. And the association with its attorney generally complied with the records request, but that wasn't good enough. The owner ended up suing and asking that the court award his attorney's fees in addition to turning over the documents. And ultimately, the court said, no deal. We are not awarding you attorney's fees because the association substantially complied with your requests. And it may not have been perfect, but they acted in good faith. They tried to comply. And some of the documents you requested didn't even exist. So they tried to locate them, and you can't come up with a document that doesn't exist. And for some of the documents that they refused to hand over, they had a reasonable doubt about whether those documents had to be turned over at all because of the rules that Mike Hunter just discussed. So the court basically said, no, you don't get your attorney's fees. You've gotten all the documents you're getting, and the Court of Appeals affirmed it. And ultimately, from what I can gather, that owner has sued that association again under slightly different grounds. That's in the appellate court now too, although I don't know if Ben Rhodes is involved in that one, but that's my understanding of the case from an outsider's perspective.
Yes, and I'll say happy to not be involved with this next one, but I think one of the things that the board did early on in this document request that really helped was we said, we have most of the documents that you are requesting. It is available online, and we can set you up access to view it online. We also said we'd be happy for you to come in and sit down in our office, and we will review these things with you in advance. And that was not good enough. He wanted it on flash drives and in paper, and it went on for months and months. And so, but we provided every bit of information that we had. There were other vendor contracts and third-party vendors that were getting contracts that just we did not have. And so, but it was a lot of effort to produce what we did, and it ended up being favorable for the association.
Yeah, and just to add to that, unfortunately, that is not a published case, so it is not binding precedent. So it may be persuasive to courts. If someone sues, you can hold that case up to a judge and say, look, this is we've substantially complied. We've withheld only documents in good faith that we don't think have to be handed over, but a court could decide to ignore that case. So that's unfortunate.
I wasn't involved in that case either, obviously, but that's a perfect example of the kitchen sink document request where it's obvious to everyone that The owner's purpose is simply to harass the board and make their lives difficult.
So, well, before we jump on to the next section, and Ben, you may address this, but a couple of questions came in around one thing you said in the last section, Mike, was about minutes, and minutes only being provided at the request, meeting certain, guidelines. Now, we make our minutes available through our portal, and can you further elaborate maybe on making them available versus only making them available upon request?
Well, yes. If you look at the way the various paragraphs and sub-paragraphs are laid out in the statute, there's a list of 6 different documents that owners are entitled to unconditionally. And in there, it says minutes of member meetings are, but up above, further up in the statute, it talks about minutes of the board meetings, and that is not one of the ones that owners are automatically entitled to unconditionally. However, in practice, most every HOA board makes those board meeting minutes available, posts them on the website, and can and should, because that's transparency.
Okay, thank you. Ben?
All right, so we're going to shift in sort of away from the statutory requirements and just talk more about some specific tricks of the trade, if you will. But before we get into that, I'm going to go over what governing documents HOAs have. And that seems like a very basic concept, and it is, but you'd actually be surprised how many HOAs and condos don't have all of their documents. So at really the top of the hierarchy are your articles of incorporation, but rarely are those all that helpful. Your main document is your declaration, or for a condominium, it is called your declaration of condominium. And if you're talking about South Carolina and it's a condominium, it's actually called a master deed. And that really specifies most of the important information about your community, which includes usually obligations for the payment of assessments and what you can and cannot do with your property. And I have actually recently come across 2 communities where this was a serious issue. There were actually 2 different condos in South Charlotte that we represent, and one of them had their declaration of condominium, and I don't know how long they've had it in their records, but they were missing page 19. And I only remember that because page 19 was the most important page they had. It said what people could and could not do with their units. And they had not had it for years and years. And I don't know how they got by, but they didn't have it. And then I also had an old condo with a cost sharing agreement. Literally, there's a condo next door to them, and the developer had allocated sharing of costs for the pool and clubhouse. And they didn't have that. They had no idea why they were paying the other, or actually a master association. They had no idea why they were paying it or how much. So you also have bylaws. As I mentioned earlier, in North Carolina, your bylaws don't have to be recorded, and oftentimes they're not. In South Carolina, you do have to record them, and your bylaws aren't usually that helpful. They contain things like how to conduct meetings, how to conduct votes. You also have rules and regulations, and those are things like your pool and clubhouse rules. If you have a delinquency policy, if you have architectural guidelines, you really need to keep all of those up to date, and you need to make them readily available to owners if they want them. Most management companies, and I'm sure CAMS does this, they have them on the website, so anybody has access to them at any time. And that's a good thing, because you want your owners to know what the rules are. So the other thing too is you need to make sure that they are not outdated. I have seen a number of cases where an HOA will have posted its architectural guidelines, but they've been amended since then, and they've never posted the newest ones. So members don't even know what they're supposed to do. There is some pending legislation, at least in North Carolina, that it will require additional corporate records to be provided by HOAs and condos, and specifically that they're going to have to submit an annual report each year to the Secretary of State's office. And that's just not something they currently have to do. It's really like a one-page document, but that's an additional hassle for HOAs potentially if the law gets approved. The other thing too is to keep your registered agent up to date on the Secretary of State. And both North and South Carolina nonprofits have to appoint a registered agent. And that is really a person whose sole job is to get lawsuits and hand them over to the association if the association gets sued. And it's a real problem if you don't keep it updated, because if a lawsuit gets filed and served on the registered agent or who should have been the registered agent, and it's not handed over to the association can lose. So you got to keep that up to date. We have already discussed meeting minutes, but we'll get into a little bit more detail. Really, every meeting should have minutes, and it's really a hassle to do that. I've often heard it said, and I think it's true, that the most important person on basically on a board or an officer, a group of officers, is the secretary. And the secretary is really responsible for keeping the minutes and making sure they're accurate. And you should have minutes for every meeting, including meetings held in executive session. What Mike mentioned earlier is for meetings held in executive session, you should really have a separate minute book where those are kept basically under lock and key, and they're only accessible to the board of directors, and they are not accessible to members generally. You should really only hand those over if a court tells you to. Another thing that some communities don't do but should is if they have, let's say, a meeting strictly to meet with their attorney to go directly into executive session, they should keep minutes that literally say the board called the meeting to order at such and such time and then went into executive session, so that you've got a record of when the board actually went into executive session. So minutes are basically up to each community to decide how extensive or voluminous they should be. But you really don't need to have voluminous minutes. A minute should really only tell you what happened at the meeting. You really don't care who said what. You don't necessarily need to know who attended the meeting, but you really want to know what happened at the meeting. So what you would really need in your minutes is if someone poses a motion, you need the specific motion and the outcome of the vote on the motion. So that's really what your minutes need to have. And really communities should have a template for their meeting minutes so that it's not, you're not reinventing the wheel every single time. As we mentioned earlier, members are generally entitled to minutes provided they meet the requirements that Mike said, at least for board minutes. They have to show that their request is made in good faith. They have to describe really what they're looking for, and the records have to be related to that purpose. That includes board minutes as well. Membership meeting minutes, they're fair game. People can have them at any time. And I think I covered executive session minutes, but again, just do not disclose those. Those should always be kept private. You can talk about things like contract discussions, personnel decisions, litigation. You should not go into executive session, though, just for controversial topics. Even if something is going to be a hot button issue, just because members are going to be riled up if you put it before a membership vote or once they know about it, that's not a reason there to go into executive session. You have to have a specific reason to go into executive session. So shifting gears to architectural applications. This is obviously architectural requests are a type of record. You really don't need to generally provide owners with the actual request. But it's my position, at least, that if a board or an architectural committee makes a decision, approve something for someone's property, that is an official record of the association. And if they jump through all the hoops, then a member can probably have that. The biggest thing with architectural applications and decisions, at least in my experience, is that boards or committees may not always be clear on what they approve. Most of the disputes I see over architectural topics are because a member misunderstood what they were approved to do. The way around that is to have very clear architectural application forms and have a very clear and specific response form for the committee or the board to fill out every time, and they should follow it every time. Our courts have generally upheld architectural decisions, but there's a number of factors that go into that. If an architectural committee or a board denies an application, there's a few factors that courts look at, and if an HOA meets those factors, courts generally won't second guess the decision. One is whether there was a personal inspection of an owner's property, whether other owners were consulted, whether the reasons for the denial were clearly stated to the owner, were alternatives posed to the owner. So rather than just rejecting an application, are there things an owner could do to comply? That's what that means. And did the committee or the board consider their application multiple times? And I think it's a best practice to include all of those in the response form so that your committee essentially is going through all of them and checking the box for every single architectural application. And I actually last week encountered a situation where a board of directors went to an owner's lot. They had 4 directors and all of them went to the owner's property. They say they approved one thing. The owner says they approved something different, and none of it was put into writing. And the funny thing is, I know they have a good architectural form because they paid me a lot of money to draft it, but they didn't use it at all. And now the owner's hired an attorney. The owner cut down a bunch of trees in the common area to remove a bunch of larger trees from his property. And he says he had approval. The HOA says he didn't. So that's headed towards a lawsuit. I will shift to record retention. This is something that a lot of communities don't really give much thought to, but record retention is very important. Not only because the statutes require some records to be kept indefinitely, but it can help you out in the long run and keep you out of trouble if someone files a lawsuit. And really, with modern technology, there's no reason you can't keep records forever, but you really need to be careful that you have safeguards in place that nobody can get an owner's can get a password to access financial records and things like that. And you need to be sure that if there's insurance coverage that's not obscenely expensive, that you could get it in case those records are compromised. Hacking into computers and things is obviously a big concern nowadays. So sometimes there's insurance, sometimes it's really expensive, but certainly something to explore with the insurance agent. So for record retention, I have come up with what I think is a pretty good set of standards. First are that you should keep certain records for 3 years. And these are things like credit cards and cash receipts, invoices, bank records, non-construction related contracts. And you should probably keep proxies and ballots, but those should be kept under lock and key, basically. You don't want owners to know how other owners voted in most cases. And the reason there's 3 years for most of these is to sue under a contract, you generally have 3 years to sue. If you wait 3 years and a day, you lose the right to sue. So that's why you want to keep it for 3 years so you can defend yourself in a lawsuit if you need to. I came up with an 8-year time period for a lot of other documents. And this is a little bit arbitrary, but I think there's some sound reasoning behind it. Employment and personnel records, you want to keep those for really at least 7 years, because I believe, and I'm not a tax lawyer, but I believe that's how far back the IRS can look into whether you're paying taxes on your employees or vendors, things like that. You should keep your communications to or from members. I say 8 years, the Nonprofit Act says 3. I think you should just keep them for a while because they can be helpful. Construction related contracts should always be kept for at least 6 years. If you're in South Carolina, definitely 8 years. And the reason for that is construction disputes can oftentimes be brought as far out as 6 years in North Carolina or potentially 8 years in South Carolina. So you should definitely keep construction contracts, maintenance records, warranties, and some warranties are even longer. A lot of roof warranties are 10 to 20 years. So you should keep those for a very long time. And perhaps a good thing for boards to do as a best practice is to review warranties on an annual basis to make sure that all the board members are aware of them. What I've seen recently is a condominium that got their roofs replaced, and then they hired a different vendor to do some repairs and voided their warranty. If they had just looked at the warranty, they would have checked with the vendor that did the roofs and they wouldn't have voided it. Accounting and tax records, again, there's a 7-year look back, I believe, when I last researched it at least. And I said 8 years, give yourself a little bit of a buffer. 1099s and membership files. You want to keep a member's contact information, so if you have to reach out and ask a question or something arises, you have it. And then lastly, permanent records. And a lot of these are things that are you would expect, but they're things like your declaration, your bylaws, resolutions, things that govern really how the community is run. But it's also helpful to keep reserve studies because you can look historically what happened and what maintenance has been done and things like that. You want to keep violation notices and hearing results. Again, keep those private, but you need to know what happened in the past sometimes to either defend yourself currently or just to make sure somebody's not in violation again. You should keep your annual budgets, obviously your legal documents, things like legal opinions. If you've terminated a contract, you need that in case a lawsuit arises, or just you don't want to spend money a second time for a legal opinion if you've already got it. You want to keep your real estate documents indefinitely. Tax records, I said forever, but really the tax office can look back in time 10 years. So it's probably a good idea to keep it forever. If you have licenses and permits, keep those. Not very many HOAs have trademarks, but there are some. You want to keep all that handy. Insurance policies and insurance claims, you definitely want to keep those. And then accident and injury reports are also good to have. That can kind of cut both ways. Obviously, if you've had an injury, you want to fix something that caused the injury, but you also want to be able to defend yourself if someone says they were injured and you can prove that you fixed it the first time or that you paid them off if there was a lawsuit, for example. And that really covers most of what I had to say. I know that we have built in some additional time for questions and answers.
So, well, thank you, Ben. We do have a few questions that have come in. So committee minutes and committee sessions, how should those minutes be shared and posted?
Well,
I would say absolutely. I mean, why not? And I don't know if Robert's rules actually requires that, but obviously if a committee is going to be making decisions that impact the community, there's no reason not to have minutes. Ben, you got anything to add?
well, I was going to say certain types of committees you have to. For example, your architectural committee. What the statutes say is that, let's see if I can find it here. I can't find the exact language, but they say that if you have a committee making decisions basically in lieu of the board, then you have to keep a record of that. So your major example of that is your architectural committee. They're basically acting in the place of the board and making architectural decisions. So you have to keep that. But I generally think transparency is a good thing. If you shouldn't have anything to hide in your minutes, and you can avoid a lot of questions from owners by just posting your minutes. If people have a question, they can look at the minutes.
Okay.
As board terms begin.
Wait a minute. I just pulled the statute up.
Okay.
It does say a corporation shall keep as permanent records minutes of all meetings, ... A record of all actions taken by committees of the board of directors. Now that says a record of actions. It doesn't say minutes, but that's what minutes are. Minutes are a record of action. So yes,
Okay.
committees should take minutes subject to the same guidelines that been discussed. It's not, your minutes are not supposed to be a transcript of everything that was said. It's supposed to be a description of the action that was taken.
Okay, so as board members change and turn over from term to term, what responsibility do prior board members have to incoming board members to turn over research or other documents that they may have researched over their term?
Well, absolutely. Retired or former board members who are in possession of documents that belong to the corporation absolutely need to turn those over. Those records do not belong to the individual. They belong to the corporation. So absolutely, those documents should be surrendered when they resign or vote out of office or whatever, no longer on the board. Absolutely.
Okay.
I actually had a disgruntled former board member who refused to hand over his corporate notebook, and we had to intervene and basically tell him, if you don't, then there's going to be problems.
So what's the best practice for sharing violations and other information that may be sensitive to the membership?
Well, I touched on that earlier. Correspondence sent to only one member or subgroups of members or less than all the members are not subject to inspection. So violation notices should not be sent. Now, if the board wants to give a tally of, we received 3 fence violation notices this week, or we issued 3 fence violation notices this month, and then over the past 6 months, we've issued so many landscaping violation notices, et cetera, but you cannot provide copies of the actual correspondence that was sent to that violating homeowner. But it's the same as the election and ballots. You can provide a tally or a summary, but you can't provide the specific letters themselves or any identifying information. And same thing with delinquent accounts. You can provide a summary of the overall accounts receivable, but nothing that identifies any particular homeowner's debt.
So the metrics behind 10 grass violations and 5 trash can violations.
Exactly. Yes.
Okay. So you mentioned earlier about sharing vendor contracts. What are some legal reasons that you may not want to share those contracts with the membership? Ben,
you want to take that one?
Yeah, there's a lot of reasons. One is a lot of times it's confidential information. The landscaper probably has a specific price that they have for their services. And if that gets out to the members, then any other landscaper can use that and potentially harm the vendor's business. A real world situation where I've had a problem is sometimes a member will get their hands on a vendor's contract. In my case, it just always happens to be the landscaper, and a member will just have an axe to grind with the landscaping company, that they're not coming out frequently enough. And I've had several instances in different communities where an owner will contact the vendor directly and demand that they meet the terms of their contract. So that's always interesting. And really the member is probably exposing himself or herself to liability by doing that. But I've seen that happen, and that's always an ugly situation. A lot of contracts also say that they are confidential and not to be disclosed. So if the board inadvertently gives it out, then potentially they face a breach of contract against the vendor. So that's another reason. There's quite a few reasons, and you really also don't want owners picking a contract apart most of the time. You're always going to find an owner that says, okay, you hired this company, my cousin could have done it cheaper, and it's, well, maybe, but the board, as long as the board does its due diligence and considers whether the vendor is in the best interest of the community, then the board shouldn't be second guessed on its decision.
And the other overarching consideration is the cheapest price is not only, or the cheapest vendor is not always the best vendor.
Okay, question with minutes. Do you have to record how a board member votes on a motion?
No, the minutes should reflect the vote tally saying, a motion was made to approve ABC Landscaping's contract. The motion passed by a vote of 4-1. That's all you need to say. You should not identify which board members voted which way.
Yeah, and there may be, well, there is a way under Robert's rules that you can require a roll call vote, but it's rare and it really shouldn't happen much. You really shouldn't care about the identity of who's voting.
Especially in a board meeting.
Yeah.
So, as opposed to a membership meeting.
So with executive minutes, you mentioned something about keeping them locked away. And this is executive session minutes. So should those minutes be shared with the management company?
Generally, yes, but not always. We don't really get involved as a firm in discussions about management contracts. But let's say a board either wants to hire a management company or wants to fire a management company. They could go into executive session and discuss that. And obviously you don't want to share that with the vendor. But there's also times when you've got privileged communications strictly with the attorney that you may not want to share with anyone else. And I'm not even necessarily saying that, you're adverse to the management company, but there's times when you've just got very sensitive things that are discussed strictly between the board and the attorney. So you have to be, you kind of have to consider it on a case-by-case basis.
Okay, you talked a little bit about record retention, and in North Carolina, is there anything different that you would recommend for record retention in South Carolina?
No, I think the same general time periods apply, and again, some of them are arbitrary. I'll admit that some of them there's no real magic number to it. I just kind of came up with numbers that make sense legally, but there may not be a strict requirement for it.
See, a lot of those deadlines or the retention periods are based on the statute of limitations for various types of issues. And for example, as Ben said, the statute of limitations for a contract action is 3 years. The statute of limitations for breach of a restrictive covenant is 6 years. There are other issues, for example, construction defects could be 4 years, could be 6 years. There are other issues that the statute of limitations is 10 years. So a lot of these document retention guidelines are founded in the underlying statutes of limitations for what types of claims could come out of those. But as he said, it's not an exact science. It's more of a guideline.
So question around changing management companies, and we'll say not leaving CAMS. This is coming from or to CAMS. If a management company or prior boards don't have the records, how does an association deal with not having the records that may be requested?
Ben, you talked about that earlier Ben Karb talked about that earlier in connection with that appellate case. I'll let you take that one.
Yeah, you just got to use reasonable diligence and use good faith and try to come up with the records. If it doesn't exist, you can't create something out of nothing.
And so I can say with record retention, we try and turn over everything that we possibly can. Most management companies will turn over everything they have, and they generally will send it in flash drive format or PDF format, where the management companies are sharing information for retaining that information as much as possible. So we do work with our competitors to make sure that information does change hands. There was a couple of questions, maybe more general questions around document amendments and maybe the recent law that, or the court ruling, should say the appellate court ruling about documents and updating documents, and if there is a need to update the documents that may be outdated. Could you comment on that?
That's a very broad question. I mean, if you've got a set of covenants that are outdated, I mean, I have a lot of communities that come to me with a declaration that was drafted and recorded 20 or more years ago. And yes, a lot of those are, some of them were pretty well done. Some of them were done in accordance with the standards at the time and under previous law. It just, you can't make a blanket statement about whether or not your documents need to be amended. But what I generally say is, if you bring to me your declaration and said, hey, do we need to amend these? I can always look at a set of documents and find things that could be improved. But as the old saying goes, if it ain't broke, don't fix it. Unless there's a good reason to do it, why spend the money? But there could be a lot of good reasons to spend the money to do it. It's just, you have to take it on a case-by-case basis. And it just depends on what the particular documents say and what type of issues that particular community is dealing with.
Okay, and I'll just add, we did a webinar on amendments. I think it was about 2 or 3 sessions ago. So if you are interested in watching that webinar, we do talk a little bit about, you know, best practices with amendments.
Mm-hmm.
Rules and regulations are not written in our official documents. Can the board create those, or does it have to be written as an amendment that is voted on by majority or 2/3 of the membership? And specifically talking parking restrictions and move in, move out rules.
Ben, I'll hand that off to you.
Yeah, well, there's not a one size fits all answer to that. Sometimes, and actually in most communities, a board can freely adopt rules and regulations, but it has to do so that as long as they are consistent with the governing documents. So you can't adopt a rule or regulation that is contrary to your declaration. But usually boards can adopt them however they want upon a board vote, but not always. Sometimes you'll see a document, oftentimes an older one, that says the board can adopt rules and regulations if 50% of the members approve them beforehand. And those are always a pain in the neck, but sometimes your documents will say something like that. Anything to add?
And typically, there's no question that the board has the authority to adopt rules and regulations governing use of the common areas, because that specific authority is granted in both the Plan and Community Act and the Condominium Act. Where it gets dicey is where the board is trying to regulate what owners are doing on their own property. That's where it gets dicey.
That's a good point.
Okay, how long do we need to keep violation notices?
Well, I would say indefinitely, but legally you probably could get by with 6 years is arguably how long you could keep it, because to enforce an easement or a restrictive covenant, there's a 6-year statute of limitations. So anything beyond 6 years, you probably can't enforce, but it may be helpful to keep it.
Should amendments be integrated into the last document version or kept in a separate document?
I'm not sure I understand the question.
I'd say I've seen some communities rewrite their documents,
Okay. Yes.
including amendments.
Yeah, and that's a good question. If I have a community that comes to me and they've got a list of 3 or 4 or 5 things that they want to change in either their bylaws or their declaration, I can typically do that with just an amendment. But and I see this a lot, and I hate to say it's mostly, we see a lot of horribly written documents in the western part of the state. And a lot of times these communities will come to us and say, hey, we've got a problem with X, Y, Z. And I look at their documents and I just scratch my head. Oh my God, what was the attorney thinking who drafted this? If there's so much that needs to be fixed, you're better off with what we call an amended and restated declaration, or amended and restated bylaws. But basically, we just wipe the slate clean and give you a new set of documents that are basically what we would use if we were developing that community today. completely up to date. And there's a couple reasons for that. Number one, if you've already got 2 and 3 and 4 amendments that have already been done to your declaration before, and here you're doing a 5th one to add 3 different changes, if someone wants to know what the declaration says, they've got to look at 6 different documents and try to incorporate all those into one. So if you get to that point, the best way is to do an amended and restated declaration, which means you just rewrite the whole thing and take all those previous amendments and incorporate them into one. And let's start with a clean slate with a brand new set of CCRs that has everything in there we want, that replaces everything that had been done before.
Okay, we have questions keep coming in, so we'll probably go another 5 minutes if that's okay, Mike, Ben.
Yeah.
So should an ARC have a member of the board on the committee, or so the Architectural Review Committee have a member of the board on the committee, or should there be clear separation between the Architectural Control Committee and the Board of Directors?
My opinion is that that's completely up to them. You have to look at your bylaws, because a lot of the bylaws say that the board can appoint committees, but at least one member of the committee also has to be a board member. But there are plenty of committees that don't have that requirement. So it just, there's no requirement either way. As long as remember, the committees have to report back to the board anyway. And so I don't think it's absolutely necessary for there to be a board member on the committee, but it just depends on your circumstances.
Yeah, and I'll add to that. You really want your committee following the board's direction. You don't want a rogue committee that is not in close contact with your board, because you're going to get conflicts between what the board's telling people and what the committee's telling people. And that's just a recipe for disaster. So you need everybody on the same page.
Solar panels. So we're into the very general section of this webinar. So can you comment on solar panels and how they need to be addressed in the Carolinas? Well,
funny you say that, because there is actually, North Carolina many years ago adopted a statute. The legislature adopted a statute that basically limits how far community associations can go in restricting solar panels. Basically, what it said is the HOA can only prohibit panels that are on the front slope of a roof facing the front of the house or a street, in the front yard, or on any side of the house that faces a common area. And I'm summarizing this, that the statute was horribly drafted and difficult to interpret, but that's what it said. Well, there's a bill that's been introduced in the legislature basically to eliminate all that and say, basically what it says is HOAs cannot prohibit placement of solar panels anywhere if it would make the solar panels 10% or more less efficient than the homeowner's desired location. So aesthetics, if this bill passes, aesthetics are no longer an issue. Doesn't matter if your panels can be seen from the street or from your neighbor's lot or anywhere else. That's what's been proposed.
Yeah, and just to add to that, there was an appellate case 2 days ago out of, I believe it was Durham, but I may have the county wrong, where basically an HOA had the ability to regulate improvements on an owner's property, and an owner, but solar panels were not specifically defined as an improvement, but they were not, the word solar panel never actually appeared. An owner installed solar panels, the HOA got unhappy, started fining the owner, and the case made it all the way to the appellate court. And the court basically said, if your HOA has the ability to regulate improvements, then you can follow the statute and prohibit solar panels on this front facing roof. This downward slope.
In this case, the homeowner had mounted the panels on an arched roof on the side facing the front of his house in the street.
Yeah.
So in the category of routine communications with its member or the association members, what's the best practice for communicating after the conclusion of a major project?
Well, I'd say that's more of a management issue, Ben, than a legal issue. What do you think?
So I think you need to know your audience and know the expectations of the membership. And so it would probably depend on how the residents need to know and what type of information you want to share as a board. So, but
And I imagine the extent and the cost of the project would be a big factor in determining how important it is. If you just restripe the parking lot, does everybody really need to know that?
So when it comes to attorney-client confidentiality, can you offer any guidance or interpretations between the board and the lawyer on how you share those interpretations of the covenants to its membership?
Well, here again, that's what I talked about that earlier. If the board comes to me for an opinion on a particular issue, before I write the opinion letter, I have to determine whether this is something that needs to remain confidential, attorney-client privilege, or if it's an opinion letter I'm writing with the full expectation and knowledge it's going to be shared with the homeowner who's complaining about it, or with the community as a whole, or just some of the homeowners. So it just depends on what the issue is and how sensitive it is, and is it covered by attorney-client privilege. But as I said, a lot of opinion letters I write with the full knowledge and the board's full knowledge and understanding that that opinion letter is going to be shared with the homeowner.
Any advice on how and where communities should keep records? Should they be in the paper format? Is digital format okay? Should they be in the community, or can they be at the management company?
I think they should be saved electronically these days. Paper records are a thing of the past at this point. I would say a hard drive, flash drive, but also backed up in the cloud. That would be my opinion.
And I'll just say, we do save everything electronically. It is scanned and it is backed up. So we have a full service IT department that does handle that for us. So everything is backed up. Is it beneficial to have a sounding board, or is that just asking for trouble?
I'm not sure what a sounding board is.
I don't know either, but I'd say maybe more of a forum for, let's say Facebook sounding board. Should the board participate in a forum type discussion?
Well, my opinion on that is the association itself or the board should not maintain Facebook pages, next door pages. I've seen so many communities get into trouble with those because of things that owners post on there. We have enough problems with community pages that individual homeowners have set up, and all kinds of nasty things get said, and false and defamatory statements. In fact, I'm dealing with one right now where it's a Facebook page where actually some of the board members have administrative rights and some people who are not board members have administrative rights. And there's been some false and defamatory statements posted against the board of directors. Some of those statements were posted by another board member. So, I mean, what's been your experience with those, Ben Rhodes?
I do not prefer Facebook.
Yep.
We tend to encourage people to stay off of Facebook and try and handle it more as a one-way communication. We want the community to hear, from the association or the management company, as an official post from the management company, not through Facebook. So we do discourage Facebook, Nextdoor, and other social media applications.
I've seen much more bad come out of those social media websites than I have good.
Yeah, and I'll add one thing too. I think the board should take the community's opinion into account. You should do things that the members want, especially if it's a architectural type project. But ultimately, the buck stops with the board. If you start asking your members to vote on certain architectural things or contracts or things like that, you're going to get mired down in everybody's different opinions. The board has to make the decisions ultimately. So you can take people's opinions into account, but the buck stops with the board.
Right. Well, it is 5:45. So Mike and Ben, thank you very much for joining. We'll make these slides available to everybody, and the Q&A portion of this is also posted on the CAMS website. So this is recorded, and you will have access to this recording, others to view. So again, thank you, and we will be doing the drawing for our 30th anniversary after we close down the meeting, and then we will contact the winner. So Mike, Ben, thank you, and good night.
Thank you for giving us this opportunity. We appreciate it.
Thank you guys.